Are we ready to start? Can I just check if we have everyone before I can accept the judge in? Does good morning. Am I audible?
Yes, I can hear you.
Thank you
It's
so
Peter
much.
Smith here for the second and third respondents.
Second and third. Thank you, Mr. Smith.
Good morning.
Good morning.
I'm Lisa Loresh from Peter Schrein Attorneys.
Lisa.
My counsel is just struggling to get into this meeting, so if you can just give him a few minutes. He says there's something wrong with the link from his side, so I'm just trying to figure that out.
Not a problem.
Thank you.
Counsel for the applicant?
Yes, that's my counsel.
That's your counsel.
Yeah, Controbler, yes. No,
Oh.
that's for the first respondent. Sorry, it's for the first respondent.
All right.
Thank you.
Thanks.
Good morning. Good morning, ma'am.
Good morning.
Good
Good
morning.
morning, Mr. Good
It's
morning.
Norman Arendse. I'm here with my junior Ishit Cohen
For the SIU?
for the SIU for the applicants. Yeah,
Thank you.
and I see that Mr. Walser is on from the SIU. I don't see Stella Zondi on yet.
No problem. Thank you.
Okay, she'll probably join shortly. Thank you.
Can I just confirm if the fourth, fifth, and sixth respondent are not represented?
Yes.
Okay.
Hi, good morning, ma'am. I appear on behalf of the sixth respondent, Ms. Colliper.
Oh, Ms. Goldman. Thank you.
Thank you. We do abide. However, we are here if the presiding judge requires any clarification on any issues.
Thank you so much.
Thank you so much.
Thanks. We'll just wait for the counsel for the first respondent. I do know that we have some difficulties this morning with connection and receiving the link. Apologies for that. This load shedding has not been easy on us. Please let us know once your counsel is able to join.
Hi, ma'am. He's still struggling to get in. It says there's a fault in the link. He's trying his best. If you can just give him a few moments. Apologies
Yes,
for this.
Just let me
Thank
know
you.
once.
Okay, thank
once he
you.
has joined,
Thank
and then I can get the judge to join. Thank you.
I will let you know. Thank you. Apologies. Good day, thank you. My counsel has just joined.
Good morning.
Thank you. Thank you, my lady. We may start. Good morning, my lady.
Good morning, my lady.
I will
I
place the
will
matter
place
on
the
the
matter
court.
on record.
As the court
As the
pleases,
court
my lady,
pleases, my lady,
this is a matter
this is a
between the
matter
Special
between the
Investigating Unit and Seasport Consumer Connectedness Pty Limited and 5 others, case number FS01 of 2022, appearing in the Special Tribunal of South Africa before Madam Justice Mdiba, 24 April 2023. My lady.
Council may
morning.
place themselves on record.
Good morning, my lady. Norman
Morning.
Arendse. I'm appearing with Eshad Cohen for the applicant, my lady.
Appearance noted. Thank you.
My lady, good morning, and may it please you, my apologies for the late start. I had some technical difficulties here. My name is Stefan Grobler. I appear for the first respondent.
Thank you, Mr. Grobler.
Morning, my ladies. As it pleases the tribunal, it's Peter Smith from the Johannesburg Bar. I appear with my learned junior, Mr. Mpositaba, for the second and third respondents.
Appearance noted. Thank you, Mr. Smith.
Good morning, my lady. Kurusha Colifin from the Pretoria Bar. I appear on behalf of the 6th respondent. Your ladyship would note that the 6th respondent is abiding. However, we appear today for your ladyship's any clarification or issues that require explanations, my lady.
Thank you, Ms. Colpin.
Thank you.
I didn't give prior indications of the time that I would afford each party to address me. I am aware that we've reserved 2 days for argument, but I'm not persuaded that we need 2 days. But I'm mindful that you may have prepared to exhaust the time that we have. Can I just have an indication of how much time you require to address me?
My lady, in anticipation of your observation, we don't think that we will require more than 1.5, 2 hours, my lady. And
I'm very happy to hear that coming from you, Mr. Arendse.
Oh, okay. I don't know. I wasn't aware that my reputation precedes me, but yeah. So
your heads of argument just attest to that reputation.
thank you, my lady. Well, I think that's the whole point of comprehensive heads and the need for
And
less.
if you don't need to take me through that, right?
Thank you.
Yes.
Yeah.
Thank you, Mr. Grobler.
My lady, sorry, just one moment.
You seem to have 2 connections. That's why you have an echo. So please get rid of one.
Oh, yes.
Now you are muted on both connections. Please terminate one connection.
I have done exactly that. Thank you for your ladyship's most gracious advice. Can you hear me?
Yes, I can.
Sorry, my lady. My lady, I don't think that I will be longer than an hour or an hour and a half, dependent, of course, upon what my learned friend, Mr. Arendse, has to say on behalf of the applicant. But I say this tongue in cheek. I don't have the reputation of being long-winded. I do seek some latitude, but I'm not known for being asking for longitude. So hour and a half is fine.
Yeah, and that's not what I meant when I addressed Mr. Arons. The appropriate word is comprehensive and not long-winded.
That's the way I understood it as well, my lady. Thank you. I think
I'm not persuaded that you need an hour, Mr. Grobler, because your grounds of opposition are quite succinct. Your heads are. So I'm not persuaded that you need that long. So I'm going to ask you to not to be elaborate in your response. Yes. Mr. Smith?
That's entirely fine. Thank you, my lady.
Yes. Mr. Smith?
Thank you, my lady. My lady, we also filed what we considered to be relatively full heads of argument. We'll just highlight our main submissions to you, and I don't anticipate we will be more than an hour.
Thank you. So from what you say, we were going to be here the whole day. We'll just see how it goes, but don't take more time than is necessary. I think we'll all take cue from Mr. Arons's address. And there's no need for any counsel to read their heads of argument to me. You can just highlight, deal with the substantive issues that arise without necessarily reading through the heads. Mr. Arons.
Thank you, my lady. My lady, may I, what also assists or helps in terms of the time management in this case is that we have reached a settlement agreement with the fourth respondent, Mr. Log.
It's okay.
Hopefully your lady has been furnished with a draft order, and I would have expected Mr. Log to at least put in a formal appearance here this morning, because we obviously want to move.
When was the draft order sent?
It must have been sent on last week, Thursday, Friday. Is your ladyship not in the receipt?
I apologize, my lady. It's Bobby Walser from the SIU. We've not sent it because we were struggling to get it scanned in and so forth. I'll send it. I'll email it to your registrar now. Thank you.
Thank you. Yeah, I had received a draft order, so I didn't look at it because I expected that it would accord with what's prayed for in the notice of motion. So I considered it for my convenience in the event that I'm with the SIU writing the judgment. So that's why I hadn't looked at it. But as we hear from Mr. Walser, it's not been sent.
Okay, so can we?
I think it's problematic if I'm being made aware of a settlement in this manner, because I'm not a rubber stamp. Right. So the fact that you've agreed doesn't mean I will accept that settlement. So it is problematic. I should have been made aware beforehand. And the SIU is aware of the procedural steps that ought to be followed to have a settlement agreement being made an order of court. But of course, through my registrar, I will engage with the relevant parties after today's hearing regarding the draft. The draft order by consent.
Apologies for that, my lady. We accept as council. We expected at least the draft order to be sent to you to alert you to the settlement, and absolutely we agree that you're not a rubber stamp. That's why I commented that I'm surprised that Mr. Log is not represented here this morning, exactly for that reason, that you may have a problem or raise issues in relation to the draft order, which either we or counsel for Mr. Log would have to explain or account for. If
was a compromise reached, or is the settlement in relation to what was claimed from Mr. Log?
It is in relation to what was claimed in the alternative. That's the the profit, the alternative, the profit amount of 348,000 in terms of 1721B of the Constitution. So
if there was no compromise, then I shouldn't have a difficulty. Normally, I do require more from the SIU if there was a compromise.
It's not for the full contract
but
amount.
As I said, I will engage with the parties after this hearing.
Thank you, my lady. So, my lady, just to kick off, I think what is quite an astonishing feature of this case for anybody who looks at the facts is that despite our country and the rest of the world going through the worst pandemic in its history, I suppose after the Spanish flu. I'm not sure whether the Spanish flu hit us down here in the south, but certainly COVID did the whole globe. And the admittedly laudable response from the government to tackle the pandemic in various ways, and one of them was to immediately after the announcement in March of 2020 was to order that personal protective clothing, PPEs, be obtained by the various provincial health departments throughout the country to tackle the pandemic, surgical gloves, masks, etc. And prior and immediately after it became clear that the pandemic needed to be tackled in a comprehensive way, National Treasury had drawn up a list of service providers, had sent this list to all the various provincial departments and said, look, here's a list, we've checked them out, and you could contact people on the list to provide you with the various PPEs.
I'm carefully noting the use of words that you've adopted, and you're saying you could and not you must, because that's an issue in this matter.
Yes.
Right? Yeah.
Well, I mean, obviously, it was it wasn't. It was a list that was there for the convenience of the various departments.
Yeah, but was it obligatory? Because that's an issue. That's an issue here with Annexure 8 to Instruction 8.
Yeah, Instruction 8 is it's an instruction. It's a Treasury instruction. Of course, it wasn't cast in stone to the extent that there were exceptions, and we also deal with that in this case.
Yes.
But your first port of call would be to go to Annexure A and to contact these parties, and only if these parties were not available.
And where does that requirement comes from? That Annexure A should be prioritized, because it's not expressly stated in Instruction 8 that Annexure A, the suppliers listed in that annexure should first be approached.
The Annexure 8 had two purposes. The one was to facilitate emergency procurement to deal with COVID-19 pandemic, and two, to avoid the abuse of the supply chain management system.
That's Instruction 8, right? Yeah. Not Annexure 8.
Instruction 8. Instruction 8 gives effect to Regulation 16, capital A, 64 of the Treasury regulation. in the context of the COVID-19 pandemic. It was promulgated on the 19th of March 2020, just 4 days before the declaration of the declaration of a national state of emergency on the 15th of March 2020. And your ladyship's observation at the outset is entirely appropriate, because it is a key piece of legislation in this review, and it applied, we submit, when the department entered into contracts with the respondent companies. And I'm just reading from a footnote to my notes here, my lady. Paragraph 5 of Instruction 8 provides that it applies to all national and provincial departments. Instruction 8, Note 8 was in force from 19 March 2020 to 15 April 2020. It was replaced by Instruction Note 3, 2020/2021. And then on 28 April 2020, Instruction Note 3 of 2020/21 was replaced by Instruction Note 5 of 2020/2021. But when the 3 contracts that we are discussing in this case, when they were entered into, Instruction Note 8 applied and regulated the department. So in relation to the first purpose, my lady, Instruction Note 8 explains that departments were obliged to procure various COVID-19 commodities.
Yeah, I've asked you to take me to a provision that says that.
Sorry, my lady.
From instruction, I've asked you to point out the provision that says that in instruction.
Yes, my lady.
That says national departments are obliged to procure from suppliers who are listed in Annexure A. I've not seen it. I've dealt with quite a number of matters where Instruction 8 was an issue, and so perhaps you can assist me.
I'm just going to ask. Can you find it on case lines?
Yeah.
Instruction. I've just asked my junior just to find it, my lady. Because I'm just reading from my my summarized submissions. Yeah, and that's what it records, that the department was obliged to procure various COVID-19 commodities like masks, gloves, sanitizer, temperature gaugers, and so on. And then just while my junior is searching for that part of Instruction Note 8, the second purpose explains that COVID-19 related goods are not goods ordinarily procured. The high demand for these products may lead to uncompetitive and inflated prices. Instruction Note 8 exists to ensure that unscrupulous individuals do not take advantage of the pandemic to loot state coffers. To both ends, the National Treasury negotiated with a long list of suppliers for the supply of COVID-19 items. Some of these suppliers were existing transversal contractors who were able to supply to departments certain COVID-19 commodities. These suppliers are listed in Annexure A, Table 1 to Instruction Note 8. Other suppliers were not existing transversal contractors, but were suppliers with whom Treasury negotiated to supply COVID-19 items to organs of state. These suppliers were listed in Annexure A, Table 2, and then their details were provided in Annexure B. All these items by these suppliers were compliant with the relative health specifications. National Treasury, on behalf of organs of state, managed to secure quotes from these suppliers for COVID-19 items, as well as estimated delivery times. These items, prices, and delivery times were listed in Annexure A next to each supplier. So, my lady, it was quite comprehensive and detailed, and made it just easier and more convenient for the various health departments, provincial health departments, to procure these services from these suppliers. The problem with this matter is that none of the respondents remaining in this case were on the list and certainly didn't conform to the Treasury requirements. We're talking about a printing company, a marketing company, a construction company. These are the various respondents that we described. So at the outset, we submit the respondents have an insurmountable problem to explain how they come to supply, and then of course the problem with the supplies, the overpricing, the blatant fraud, changing of documents on the CSD, and especially in a situation where National Treasury had effectively done all the hard work for these organs of state, sourcing the suppliers who had quality items, negotiating prices, and delivery estimates.
Yeah, Mr. Arons, I'm not with you that the department had to procure from Annexure A. The department had a discretion not to procure from Annexure A. And in that event, there are 3 requirements that a supplier had to comply with, and they are listed in Annexure A. I just don't have it in front of me. What I remember from the top of my head is compliance with national health regulations, CSD regulations. We'll debate your interpretation of CSD registration. We'll debate your preferred interpretation of what that means. And then there's the third one. Perhaps you can remind me. So I think that's what we should be looking at, whether those requirements were met by these suppliers.
Yes. My lady, it's at your ladyship.
You can just give me the third requirement. It's national health compliance with national the regulations prescribed by the National Department of Health, CSD registration, and there's the third one.
Yes, it's clause 376.
Yes, what does it say?
Instruction. It says institutions may approach any other supplier.
Yeah, you see, they're given a discretion. They may approach any other supplier. Yeah, but that supplier must comply with these 3 requirements, right? And what's the third one?
To obtain quotes and may procure from such suppliers on condition that 1, the items are to be specifications as determined by the National Department of Health.
Yes.
2, the prices are equal or lower than the prices in Annexure A. And 3, the supply is registered on the Central Supplier Database, CSD.
Okay.
And then 377, where institutions already procured items prior to the issue of this instruction under the emergency procurement procedures as stipulated in paragraphs 8.1 and 8.2 of National Treasury SCM Instruction 3 of 2016-17, such procurement must be reported within 10 days.
Yeah, but we're not in that scenario, right?
Yeah, we're
not in that scenario.
Yeah. So we submit and we submit that we've made a case unanswerable that the remaining respondents failed to also meet these 3 requirements that's stipulated in Instruction 8. I think the first trigger that would trigger some suspicion of not following the procurement processes would be that the suppliers on Annexure A had not been contacted, at least. And the second one is...
Yeah, but I'm still waiting for the provision that says that's the first step in procurement. And I've put to you that there isn't such a requirement.
Just look at the introduction.
Yeah, we don't have to waste time on that. You've got a junior, right?
Yeah. I'm just scrolling. Yeah, I've already read back to your ladyship the purpose, and then the background to the regulations. And then the procedures. This is all under paragraph 3, COVID-19 emergency procurement procedures. The central facilitation of procurement negotiations for these items is crucial as it will assist in the following. Pre-negotiated prices based on economies of scale, security of supply, and prevent rogue and panic buying. The instruction, this is at 3.2, the instruction applies to items and suppliers listed on Annexure A. Use of transversal contracts. Items on Annexure A, Table 1 are items of transversal contracts. Institutions that are already participants on these contracts may continue placing orders as usual. Where an institution is not...
I wasn't asking that you take me through instruction 8. I was asking you a very specific question. So you can deal with it in reply, because I can see that you need time to consider an answer to this question. You can deal with it in reply.
Thank you, my lady. But my lady, we for the purposes of argument, we don't need to rely on the fact that Annexure A of the Treasury instruction was mandatory. We don't, because I think I read back to you 376, which does provide a discretion to a provincial.
Yes, but your
department.
case is that they had to, so you've gotten rid of that, and that's fine.
Yes, and then we've also, in the alternative, made that a case that even if you look at the 3 requirements, that they were not met. And at the outset, of course, I mentioned that what is quite extraordinary about this case is the fact that we're dealing with companies who, on their own, on their own.
Just take me where you deal with your case, where you set out your case in relation to non-compliance with the National Health Department specifications. I don't remember you establishing that in any substantive way.
Lady, we. The first one We submitted, my lady, that the against the factual backdrop of instruction note 8 and its purpose, that instruction note 8 imposed a default rule that suppliers listed in Annexure A ought to be approached by the department.
Yes, in paragraph 73 of your founding affidavit, and I'll say you, because in a representative capacity in relation to the SIU, you list those requirements. But what I'm asking you now is to take me where you set out your case regarding non-compliance with the National Department of Health specification requirement. Where do you make out that case?
Paragraph 62 of our heads, my lady.
Case line 01.
That's not where you would make it out, Mr. Founding Affidavit. Mr. Arons.
So I'm sitting with a carefully prepared note on oral argument to actually cut down on the time that we were going to spend on our heads of argument, my lady. So I've got that.
Perhaps you shouldn't worry at all about your heads. Just let's spend this time with you addressing my concerns.
Yes, my lady.
Because you can see these are quite real concerns, right?
Yeah. So we submit, my lady, that C squared, that's the first respondent.
172.
Sorry?
172 of our founding affidavit. We make the case they weren't registered with SMART.
At paragraph 172, my lady, of our founding affidavit.
Case lines 00175.
Case lines 001.
I got the hard copy, so the page reference is sufficient.
Page 66.
Page 66.
Very specifically, that's a very long paragraph. So in 171, you deal with the
yes.
You deal with the SAPRA registration requirement. That's different.
Yes, my lady.
1722, you deal with pricing. 173, you deal with CSD. So where are you dealing with non-compliance with National Health Department specifications?
Because 376 said that if you deviate from these Treasury instructions and the Annexure A list, then you may procure, provided these three requirements are met. And we then deal with those three requirements, my lady. A registration with SARPA, CSD registration, we deal with them. And,
okay.
and we
seeing
demonstrate
that you are harping on the SAPRA registration, let's deal with that, right? Which, in my view, is very different from the National Health Department specifications. Because those specifications do not require SAPRA registration of a supplier. Do they? They don't.
Yes, we submit that they do, my lady. I mean, and that is why Treasury had negotiated, identified these suppliers, and we submit obviously on the basis that they were SAPA registered entities, and then
put up the National Health Department specifications on the screen. Are you able to do that?
Yeah.
Okay, you can do it in reply. You can prepare to do that and then do it in reply.
I've asked my junior sis if they can do it now, my lady.
Okay.
you've got you on.
Apologies, my lady. Okay, let's maybe come back to it. I don't know why it's not. I don't think I have permission to share the screen. So maybe we
Okay,
could.
that's fine.
Yeah, we'll have to come back.
Yeah, please come back to this. Okay, let's look at the SAPRA argument. Right. Okay, I know that you are aware that I've already pronounced on the SAPRA requirement in another matter, right? Because you do refer to it.
Yes, my lady. And
you are saying that I was wrong there because I didn't consider the exclusion notice.
Yes, my lady.
I could not have been wrong because the exclusion notice was not part of that case. The SIU wasn't part of their case, the exclusion notice. But you are bringing it in here. So let's look at your exclusion notice argument here.
So my lady, we just by way of introduction, we refer to a paragraph 3761 that requires all items to be.
Okay, I just want to go to your head of argument. Which paragraph deals with this issue?
62 onwards.
From paragraph 62 onwards, my lady.
From 62.
Page 21.
Page 21. I actually don't have. I actually don't have the heads in front of me, my lady, because as I said, I prepared a note on oral.
They're your heads, so you are probably more familiar with them than I am. So firstly, you argue that the sanitizers are a medical device as defined. Right, that's the first leg of your argument. Yes. Hand sanitizers are medical device. They are a medical device as defined.
Yes.
Right. Now, in the Bloemfontein COVID matter, I've ruled that no, that matter is actually distinguishable because the PPE item that was an issue there and whether SAPRA registration was requirement was not hand sanitizers. It was surgical gowns, if I remember quite well. So that case is distinct. Right. Yeah. Be that as it may, I'm not with you that sanitizers are a medical device as defined. Right. So I'm not with you on that they're a medical device as defined.
Yes, my lady.
And then let's go to the exclusion notice. Yeah, let me just find it because I screen grabbed it so that I can find it with ease. Let me just pull it out. It does not. I don't think it applies to hand sanitizers.
The exclusion notice is exclusion of certain alcohol-based hand rubs.
Yes.
From the operation of specified provisions of the Act.
Yes, I've got it and I'm looking at the schedule. So go to the schedule because that really helps. It gives a very nice summary of the requirements, right?
Yes.
So firstly, it applies to medicine, which is not your case. So your case is not that the sanitizers were not registered as a medicine. That's not your case. So that just excludes this exclusion notice, doesn't it? So your case is not that the suppliers, the department suppliers in this matter supplied it with hand sanitizers that are not registered as medicine in terms of the Medicines Act. That's not your case. And for that reason, the exclusion notice is out of place, isn't it?
Just before I make a submission in that regard, my lady. Just wait, where in your head should we? Yeah, I'm just finding a paragraph in my head, my lady. At paragraph 67 of our heads, my lady.
Okay, let me return there.
Firstly, we see paragraph 66, section 22C1B authorizes SARPA to issue licenses to a manufacturer, wholesaler, or distributor a medical device. Regulation 27(2) of the regulations relating to medical devices and in vitro diagnostic medical devices, IVDs, published in the 20 December 2016 by the Minister of Health. The medical devices regulation provides that the Council must issue a notice in the Gazette calling for the licensing of unlicensed manufacturers, distributors, and wholesalers, which notice must stipulate the conditions and the time period for licensing, and that during the process of licensing, the unlicensed manufacturers, distributors, and wholesalers are considered to be trading legally.
Yes, but for that regulation to apply, I would have to find that hand sanitizers are medical devices as defined, right? Because the regulation applies to that.
And we submit that they are, my lady.
Okay. If I'm with you that they are, why does the exclusion notice apply? Because that applies to the registration
it doesn't apply
as a medicine.
It doesn't apply, my lady. I think the
exclusion
point
notice, so you concede it doesn't apply, right?
Yes, my lady. Yes, my lady.
So you're limiting your case to the definition of a medical device and whether that includes the sanitizer. Okay.
Yeah.
Okay, that's fine. You can move on.
So we submit in paragraph 70 of our heads that all distributors of medical devices, which included the respondent companies, were obliged to register as such and to obtain a license to distribute medical devices. And we submit that they failed to do so. The law changed with respect to hand sanitizers on 26 June 2020, months after these.
Yes, but that's the part you've just conceded that that change doesn't apply here. Right.
And paragraph 72, we say the exclusion notice excluded hand sanitizers from medical device registration subject to strict conditions. One of these conditions was that the distributor still had to apply for a license with a list of specified documents.
Okay. I'm not sure if you are reverting back to the medical, the exclusion notice, your exclusion notice case, because I thought you considered that it doesn't apply here.
Yes, my lady. Yes, we do, my lady.
You do what?
Yeah.
If you could
we do accept that it didn't apply here. Yes.
Okay. Okay, so perhaps you can deal with the second requirement, which is the CSD registration requirement. So your preferred interpretation is that it's not enough that a supplier is on the CSD. They must be registered to supply a specific.
Yes, my lady. We say that they
not really specific, but this class, this category of supplies.
Reference to age of organ. They needed to be registered on the CSD for the supply of COVID-19 commodities. Registration.
And authority for that?
Sorry, my lady.
Your authority for that proposition?
Registration per se could not suffice to satisfy the requirement of paragraph 376, Roman 3.
Yes, I'm asking for authority for your proposition, because I think this issue is coming up for the first time. We've mostly dealt with cases where a supplier is not registered at all. You know, and I know, again, some of the respondents, you made out that case. It's Eco Green, right? Regarding subsequent alteration of the CSD.
Yes,
but let's first look at an instance where a supplier is actually on the CSD, as it was with C squared, but not specifically registered to supply.
Yeah, medical supplies.
PPEs or medical supplies. And I'm asking for authority for that proposition. Do you have authority for your preferred interpretation of the CSD registration requirement?
My lady, I don't have it offhand, but as a rule, and I think it's a Treasury rule, and certainly in terms of the MFA, that in order to contract,
because you won't be paid if you are not on the CSD. It's not so much that you have to comply with procurement requirements, right?
If you, it's one of the requirements. If you, the state attorney sends you an invitation to quote.
So the process has changed.
Yeah, and one of the requirements is that you must be registered on the CSD, and
also they do require that you quote. It never used to be the case in my time, so that's changed. Anyway, that's an offshoot.
But that, because the CSD also indicates whether you're tax and VAT compliant.
Yeah, but all that is, if you're not, those issues are really peripheral. I'm asking for authority for your preferred interpretation of the CSD requirement registration, because it's vaguely stated like that, you know, that a supplier must be registered on the CSD. It doesn't specifically say registered on the CSD to supply these particular goods. Yes, does it?
But if we look at the purpose behind paragraph 376 of the Treasury instruction, the whole point of the CSD registration is that a company is a verified supplier of the commodities specified on the profile. There is no point to CSD registration if this company supplied something entirely unrelated to the products or services listed on the CSD profile. It would mean that the state has never contracted with a supplier for a COVID-19 commodity. There would be no telling if the company could provide the goods or the goods that would be of any quality. And we submit it applies even more strictly or stringently, my lady, during a pandemic like we had, because that was a quick and easy reference point. You look at this, you look, one, whether a company is registered on the CSD, and then two, you look at their profile. So they're either going to be included as part of a preferred list of suppliers, or they're going to be summarily excluded if they're not listed, or if they're not registered on the CSD. So in addition to looking at Annex A, for example, and in particular, if you're not listed on Annex A, then one would have thought that there are compelling reasons that a company not listed on Annex A, but not excluded from the work, would at least be registered CSD. So we submit that the backdrop to COVID-19 was that Treasury ensured that departments are not exploited, and through Instruction Note 8, they sought to ensure that departments contracted only with legitimate suppliers capable of supplying quality goods to curb COVID-19. The supplier we submit was at the very least required to be registered on the CSD as supplying a COVID-19 commodity. Otherwise, like what happened in this case, my lady, the department could end up contracting with a substandard goods, or worse, with a company that fronts for a third party. And this is exactly what happened in the case of Echo Green. We submit, my lady. The company had never provided COVID-19 commodities like gloves, masks, hand sanitizers in the course of their regular business. They ended up fronting for third parties with direct links to the CEO.
Sorry, that comes from my side, but it's past.
Big humanity. So they ended up fronting for third parties with direct links to the CEO of Sontaco. Furthermore, and we submit this is the primary issue, not much is known about those third-party companies because they hid behind Echo Green. Instruction note number 8 plainly intended to prevent such fronting schemes by requiring companies to be registered on the CSD as COVID-19 commodity suppliers. The respondents suggest registration per se suffices, and that you'll see from the department's affidavit. With respect, that interpretation of Instruction Note 8 we submit results in an absurdity. It means that Instruction Note 8 permitted the department to contract, for example, with a company registered on the CSD as a caterer to also provide surgical masks, and we submit such an interpretation results in an absurdity. So yes, my lady, our case is that CSD registration was compulsory, mandatory, and not only that, the CSD registration required you to indicate on your CSD registration that you were a supplier of surgical equipment, surgical devices, masks, etc. So, my lady, we submit in summary as far as the procurement requirements are concerned. We've now debated the CSD one and the health requirements one. The applicable regulations and instructions from Treasury, read with the PFMA and the Constitution, imposed 4 requirements on the department for procuring COVID-19 PPE and other medical devices. The first was the default, what we call the default rule, is that supplies listed in Annexure A to Instruction Note 8 must be used to procure PPE and other COVID-19 related medical devices. Second, and we discussed this earlier on, my lady, other suppliers could be approached if and only if, 1, the items comply with the National Department of Health specifications, B, or 2, the prices are equal or lower than the prices in Annexure A, and C, the supplier is registered on the CSD for the required COVID-19 commodities. Then the third requirement, only if an institution specifically required an item not listed on Annexure A, then emergency procurement prescripts may be followed. Those prescripts demand that an accounting officer must invite as many competitive bids as possible, but that an officer may depart from a competitive bidding process in cases of emergency. And then the fourth requirement, if an unlisted item is procured under emergency prescripts, then it must be reported to the relevant treasury within 30 days or within 10 days and to the Auditor General if the contract is worth more than 1 million rand. So my lady, I think we have so far discussed the procurement laws and the procurement requirements.
Before you move, I'd like us to debate the third requirement, Mr. Arendse.
Yes, my
I just
lady.
moved away from where you deal with it in your founding affidavit, but I think the same area where we were, paragraph 73, I think. Yeah, sorry. Well, was it in your head of argument?
It's in our heads, my
Where
lady.
you state the maximum price. Or is it paragraph 173? Yeah, I think it's 173. What's that? Yeah, 172.2, where you say the maximum price per unit was 49.86 rand.
$172.3.
172.2. I don't recall any of the opposing respondents taking an issue with this, but I'm raising it because there's a ruling I've made in another matter that Annexure A does not set a maximum price.
Yeah, paragraph 376, my lady, which is a key clause in this matter. It does say at small Roman 2, where by way of introduction, it says institutions may approach any other supplier to obtain quotes and may procure such supplies on condition that, and those are the three conditions. The items are to the specifications determined by the National Department of Health. 2, the prices are equal or lower than the prices in Annexure A. And 3,
where do you get the price for the 49 rand price from? Where do you get them from?
The top. It's in Annexure A.
Where? Anyway, this is the point I want to raise with you. If you go to table 1, item 10 of Annexure A, that item is for sanitizers. And the quoted price is 106, so it's much higher. It's double what you purport the maximum price should be to be.
Is that sanitizers or gloves, my lady?
Sanitizer detergent.
I think our reference was to gloves. 49.
So which items are you dealing with here? Is it gloves or sanitizers? Because I'm getting confused now. Because when you were arguing the SAPRA requirement, we were dealing with sanitizers. And how do we now jump to gloves?
Because we're dealing with the item on was the subject of overcharging. The overcharging was in relation to gloves. It's item 24 on the list, my lady. Item 24.
Item 24.
Yes.
And the copy that I've received from your client does not have item 24.
Is it not? But
yeah, I've got item 19 and the next page is item 38. So there's 2 pages missing actually. No, 1 page. Page 4 is missing of Annexure A. So I've got pages 1 of 14. 2 is missing. I've got 3 of 14. 4 is missing. I've got
that's the hard copy, my lady.
Yeah.
We looking. I'm looking now at
actually,
case lines.
it's just odd numbers that I've been finished with.
Apologies, my lady, but it's maybe we can give you the case line.
I've got it because these pages were printed off case lines, so I've got it. Anyway, we'll see if any of the respondents take this issue, really. Yeah. But I'm just concerned because I've made a finding elsewhere at the risk of handing down a judgment that's contradictory.
Yes, my lady. Yeah.
I had to raise it because I'm aware of that judgment.
As you please, my lady.
And that's in the matter. Mpo, please remind me, the Mpumalanga matter, Zilwa. Is it Zilwa, right?
I think we refer to.
Yes, my lady.
Zilwa matter.
Zilwa matter.
Yes. Okay.
My lady, is this a convenient point to take a short?
I also need it, Mr. Arons.
My lady, can I also just mention and not to make any excuses for my state or performance today. I had a terrible experience just last night. I had a carjacking.
Really?
Yeah, and yeah,
I'm really sorry.
I'm obviously still quite unnerved by the experience. You read about it daily, you see it on TV daily, and it could have been worse. Fortunately, my partner, she was very, very brave, and she actually pursued these guys. And then they actually abandoned the car, and yeah, it was quite traumatic. Yeah.
Amazing.
So hopefully I can.
Sorry about your experience, but I think you would not have expected this line of engagement. So
no, I do from you, my lady. It's obviously not my first appearance before you, and you always expect the unexpected, and it's good because your ladyship, you've read the papers, you know what the issues are, and obviously you hone in on those issues quite rightly, right at the outset, and I think that's how it should be. This is a case with lots and lots and lots and lots of paper, but the issues are clearly delineated, and you're quite right to identify those issues that bother you or that cause you some concern at the outset, and we should be prepared for it.
Yeah, but don't be too hard on yourself. And I'm glad that you were not harmed with your partner. I'm not underscoring the psychological harm because that's intangible. It does happen.
It's unbelievable. I think it's also, it's the first anniversary of my mom's passing today. No. So I think it was, she's still my guardian angel,
Angel, yeah, clearly.
I must confess, and it's shaken me because I'm not although we were brought up in the church, very strictly, choir boys, servers on the altar and all that. I'm not a particularly religious person. I only go to funerals and weddings. But I think I need to go today and pay my penance, for
and do take care of yourself psychologically, because this is
I didn't even phone my junior yesterday because I didn't want to disturb him, and even mentioned him, that's why you're a junior, Eshad. Sometimes when your senior can't make it, or for some reason, you've got to argue the case. I thought, no, I'm not going to jump this on him, and
that's quite gracious of you.
Yeah,
I wish you a speedy recovery, and I wish you safety. We are living in very, very difficult times. I'm quite burdened by the trajectory the country has taken. And as a person who grew up in the township, where there's a huge gap in education, and most of the instigators of crime happen to come from there. It's quite a huge burden for us who've been able to come out of that plight.
Yes,
because we understand some of the factors that contribute to it.
Yeah, no, I've
not that it's justified.
The bulk of my family by far live in places like Mitchell's Plain and Manenberg, and over the years, cousins killed, murdered, caught up in the crossfire in an overpark, and then it's just like, these things. But when it happens to you, it's not pleasant.
I'm really sorry.
Yeah, and we've done, because of where we come from. We know where we come from. Must never forget where we come from. You act in so many matters pro bono, in eviction cases, homelessness cases, and you do your part, and but these hijackers are just indiscriminately. They don't say, oh, it's you. Oh, okay, we're going to leave you alone because, you're a good guy or woman or whatever, They, I mean, to have a gun pointed at your head, it's not nice.
Yeah. On a lighter note, I think your partner's response to this just makes me sad that we still don't have a woman president in this country.
No, she was unbelievable.
As to how,
but it was also
the strength and resilience of women.
Yeah, it was also pure luck that we went to. It was a good friend of ours, a birthday party, and we decided to go in separate cars because, I've said, look, I'm busy preparing for this case, and I'll come through a bit later, and. We could have been in the same car. I don't know, what the reaction would have been had she been with me or whatever, So that was also just a pure stroke of good fortune, of luck, and grace of God. Yeah. Apologies to my colleagues for but I just thought I need to get it off my chest because it's still bothering me. Thank you, my lady.
You're welcome. We adjourn for 15 minutes, so we will be back at 22.
Thank you. Thank you, Melody.
22:12. Yes, thank you.
Court pleases.
We're not going to just minimizing. Yeah.